Hello, everybody. Hello. Sorry, the case was exporting. I thought it had a little bit more time on it than it did. We've got our Ava. Ava gets her treats. We've got our bandit baby. She has to have her medicine still. I have to do that still. I had a friend stop over, and I got out this one tough puzzle. There's 300,000 ways to get it wrong and only one way to get it correct, and we solved it. There's only 9 pieces. There's only 9 pieces. And they're in the suits of cards, and yeah, it, like, the whole idea, like, when it's done, it's like that, but that is not the answer key. So you don't get an answer key. You just have to figure it out. Yeah. I'm not gonna lie. We kind of went more by feel, like, oh, this is hard to get into this spot. This is not the piece for this. Oh, this slides in really easy. This must go here. And by doing that, we solved it. Oh, you are so patiently waiting. Yeah, so that was fun. That was really nice. I spend 24/7 here alone, other than the animals. So it's nice to have someone actually come over. Hello, Buzzy Pug. Missed you. Hello, K-John Boom. Happy birthday! Oh my goodness. I'm so happy that you got to celebrate it with your family. Hello, Eileen E. Carlin. It is April time. Oh, Ava just took her treat right off the desk. I'm not even going to be mad about it because it is yours. It is yours. And I had every intention of giving it to you, but my hands are busy. And yeah, so let me just get Bandit situated here with her nighttime med. Hello, C-Rex, honey. Hello, Nana Laura. Hello, Jerry Matthew Boyd. Ooh, Branson, Missouri. Hello, Linda Applegate, my love. Hello, Spider-Man. Hello, Mark Addy. I have not rechecked my emails, so I apologize. Please, don't hate me for it. I am the worst email person in the world. I really am. Hello, Manuel. Hello, Charlie. All right. We're going to go with beef liver. Hopefully she likes it. I'm going to give it just a little taste. Just a little taste. Oh, goody. Looks like that's going to work. They don't like the cheese one. I know. How dare they say they're from Wisconsin if they're not gonna like the cheese one? All right, baby. Let mama do her thing with your meds here really super quick, and I promise you'll get the whole stick. You just gotta wait. You just gotta give mommy a minute. All right, I just gotta mix it up. All right, you want that? Hey. Oh, Tiny Kitten and Earl went on the front porch, and they're stuck out there. I'm gonna have to let them in. I just thought of that. I'm like, oh, how come I don't have a couple extra cats over here when I've got these little licky treats? I can see you. Hello, Credence and Mikey. That's wild. Ava, that was so rude. Mikey doesn't mind though. Yeah, it's weird. So every time I go onto Credence and Mikey's streams, I try to gift memberships and I try to super chat. YouTube won't allow me. YouTube has me like banned from Credence and Mikey's channel, but Credence and Mikey don't have me banned. I don't get it. Yeah, I could do the same thing, but it won't let me. Oh, honey, maybe it found a home. I'm so sorry. Okay, I think I got everybody. Credence and Mikey, thank you so much for the super chat. And I'm really sorry. I bugged the heck out of them in Discord. I really did. I'm like, am I banned? Am I hidden? Why can't I do anything? I was really sad. Oh no, they hate me too. Trust me. They really do. Like they they do not allow my stuff to be pushed out. Like you wouldn't even believe how many people are like, why have I never seen you before? Because YouTube hates me. Hello, Lisette Panette, honey. Oh, she'll be back, sweetie. She'll be back. My daughter had a song in elementary school, and it was called "And the Cat Came Back the Very Next Day." I'm not gonna sing it for you guys. I promise. I no. Yes, it bans us all the time. It censors us. Like we're not allowed to say certain words in the chat. We've discovered that as well. Yeah. Darn tootin'. Absolutely Skippy. See, yes. Yep. And the cat came back the very next day. And that was one of my daughter's songs in elementary school. So we're gonna go to Connecticut tonight, guys. The first and nobody goes explosive or anything like that. The first one is just it's comical and in all of the original YouTube ways, but this case was from today. But yeah, I couldn't resist. You know, I just like, oh, wee baby, you have got some claws. You had 3 treats down. I'm surprised she's not eating this little pile of cat treats there. I am really surprised she has not gone for that. Uh-oh. He did too, and YouTube allowed it. Now let's see you do it, Manuel. Can ya? Oh, see, it won't. Now it won't let me say that. Like hit smack. I can't say Judge put the smack down like in chat. It'll censor it. Like I get whole walls of like try to rephrase it. Oh, it went through. It went through. Maybe YouTube's having a good day. She's off her period. We might have a couple of good weeks. And then it'll go back to being all touchy. I don't have it blocked. Like golly gee whiz. Oh. Hello. I remember that, Sean. I do. Ow, Ava. Oh. Oh my goodness. When you go to the vet, they're getting filed out. My leg cannot take you anymore. No. Oh my gosh. Yeah. Oh my goodness. My leg is I wish I could show you guys. Here, yeah. I'll take you with me. Hold on. No, you really can't really see. Yeah, you can. That's all from Ava. Just now. And I get that every night from her. Yeah. Yeah. See what I do because I love you guys? See what I put up with? Now my camera's all messed up. Ah! Oh, hold on. Yeah, this is what you're here for. Yeah, yeah. That would be cute. That would be cute. We've got a show to do. I took you with me on a magic carpet ride. Someday I may regret this, but not today.
Your Honor, we're on the record. Your Honor, we're on the record. This is the monitor. Can anyone hear me?
Yes.
Yeah.
Yes.
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 We're on the record, Your Honor.
Can you hear me?
Yes.
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 All right, Madam Monitor, am I ready to proceed?
Yes, Your Honor, we're on the record. I don't think he can hear me.
So, as I said, excuse me, I'm going to call the matters in the order in which they appear in my docket. The first matter I've got is Vaccaro versus Doe. 108, motion for order, 110, objection.
Morning,
Your
Your
Honor.
Honor.
Douglas Varga for the plaintiff.
Good morning, Your Honor.
Gerard
Andrew
Carlin.
Nevis for the defendant.
Gerard Carlin, petitioner.
Okay.
Wait, Your Honor, I'm sorry.
No,
Sean
I think
Higgins,
you're a little early. All right, Mr. Carlin, you're a little early. Yeah.
I'm sorry, Your Honor. There seems to be some kind of echo or something. It's hard to hear.
And Your Honor, your screen appears to be frozen.
Judge is also frozen for me.
Yeah, me too.
This is the monitor. I did email the clerk to let the judge know.
Thank you.
For your patience.
Am I still frozen?
Yeah, Your Honor, you're frozen and we can't really hear you very well.
Hello? Very well.
Now we can see you.
Right. Can you see me and hear me?
Yes.
Yes, we can, Your Honor.
It's like the Tommy songs. All right. Okay, let's try it again then. Okay, why don't I get the appearances in Vaccaro versus Doe again, please?
Sure. Good morning, Your Honor. Douglas Varga for the plaintiff, Ashley Vaccaro.
Good morning, Your Honor. Andrew Nevis for the defendant, John Doe.
All right, I'll hear from the movement, please.
Thank you, Your Honor. Your Honor, this is plaintiff's motion number 108, motion for order to use a pseudonym. This matter arises out of a 4-year relationship between Ms. Vaccaro and Mr. Doe that, to put it mildly, did not end well. In July of 2024, well, to back up, they were never married, but they did have a domestic relationship. They entered into a domestic partnership agreement. They entered into a formal agreement terminating the domestic partnership agreement. Both agreements had confidentiality provisions. The termination agreement had a provision saying that if there was any litigation that were to arise among the parties, that any filings would be under seal and kept confidential. So in July of 2024, Ms. Vaccaro served Mr. Doe with a multi-count complaint arising out of their relationship, making numerous allegations against him of a very personal and salacious and vindictive nature. She had claims against him for battery, assault, breach of contract, breach of the implied covenant of good faith and fair dealing, conversion, unjust enrichment, intentional infliction of emotional distress, negligent infliction of emotional distress. She alleged that he had engaged in physical, verbal, and emotional abuse of her, threatened her with bodily harm, harmed her physically, caused her to be in fear for her life.
Well, just to cut you short a little bit,
I'm sorry, Your Honor,
Yeah.
I can't hear you right now.
reviewed, or at least had access to. You can't hear me?
No, Your Honor,
No,
you're
Your
going
Honor.
in and out.
I think
All
you're
right,
saying
here's
that
what I'm going to do. Here's what I'm going to do. I'm going to connect by phone, and I'll keep my screen on if it works, and I'm going to connect by phone. So we'll take a brief recess.
Okay.
Court stands in recess.
Hello.
Hello, Your Honor. I think we can hear you now.
Hello.
You can hear me now?
Yes, Your Honor.
Yes.
Yes, we can, Your Honor.
All right. I haven't done anything, so are we on the record or off the record?
We're on the record, Your Honor.
Okay, let's go off the record for a minute.
Your Honor, we're on the record.
Okay. So going back to Vaccaro versus Doe, I will have read all the papers and have some familiarity with the background of the claims. So I guess the question is, why should I, under our rules, allow this to go forward on a pseudonym?
I'm sorry, Your Honor, you cut out again for a moment. Could you re-ask the question? I'm sorry.
It seems to be when the case goes back on the record that I'm having problems then. Why should this, under our rules, be permitted to go forward under a pseudonym?
All right, Your Honor, we had, this case has been pending now for a year. We had a status conference back in May of this year. And at the status conference, counsel for plaintiff indicated that they intended to or were contemplating at least amending their complaint to add one of John Doe's family members as an additional defendant in this matter. And it's our view, Your Honor, that this is part of an ongoing vendetta on the part of Ms. Vaccaro against John Doe and his family. She has sued John Doe. She's filed an arbitration claim against the family member who she's talking about bringing into this case, which I believe is going to be heard next week. And now she also wants to, in addition to having this arbitration claim against a person I'll call John Doe too, also wants to sue John Doe too. And the fact that Ms. Vaccaro is fighting this so strenuously is evidence of the fact that her real goal here is to destroy John Doe's reputation. And this is particularly so in light of the fact that both the cohabitation agreement that the parties entered into and the agreement that they entered into terminating the cohabitation agreement had confidentiality provisions. And in fact, the cohabitation agreement had language providing that if any litigation arose out of it, the file and the pleadings would be sealed. So this shows that the parties' intent was that in the event that they ended up in litigation with each other, it would be kept private. And the fact that Ms. Vaccaro is fighting this so strenuously right now, there's no harm to her if this protection is afforded to John Doe too. But the fact that she's fighting this so strenuously is indicative of her bad faith and her intent to simply destroy Mr. Doe and his family. It's really a thinly disguised attempt by the plaintiff to get around the September 2024 order in the Doe case and the December 23rd, 24 order in this case. Naming the relative would essentially disclose Mr. Doe's identity, and it would violate the spirit, if not the letter, of those prior orders. Arguably, the court has to grant this motion as per the terms of the prior order because it prohibits any personal identifying information about Mr. Doe from being disclosed, and naming the relative would essentially disclose his identity.
But she's a woman scorned, and she don't give a shit.
This protection is still in place. There are two appeals pending. The second one is an amended appeal from the order denying Mr. Doe's request to close the courtroom on the hearing on the original motion. Judge Gennario issued an ex parte order requiring that the case be under seal and that all personal identifying information about Mr. Doe be redacted. The hearing was scheduled on that. We requested the hearing be in a closed courtroom. That was denied. So we have an appeal from both the original John Doe order and from the order saying that the hearing would not be in a closed courtroom. The original John Doe order appeal was just dismissed a few days ago by the appellate court, not on the merits, but simply because the appellate court said that there was not yet a final judgment because this hearing had not yet taken place. Despite the fact that it's been dismissed, the order is vacating the John Doe status is still in place because the appeal is not final yet. We still have 20 days to file a petition for cert, and the John Doe orders are not vacated unless and until that cert petition is denied. And so, as I said, the second prong of the appeal, appealing from the order to close the courtroom, or the order not closing the courtroom, is still pending. So the John Doe protection is still in place. And if Mr. Doe is successful on the remaining part of his appeal, on his appeal that relates to whether or not the courtroom would be open on a hearing on underlying motion, if he's successful on that part of the appeal, there will be a hearing in a closed courtroom on the underlying John Doe application. So the John Doe protection is still in place pending a ruling by the appellate court on any cert petition, and it's certainly possible if Mr. Doe prevails that denying this current motion that's before the court today would essentially render the appeal moot. And I question why else would the appellate court have allowed the second prong of the appeal to proceed, to remain. It's so that we can have, if we're successful, have this hearing in a closed courtroom as to whether or not the underlying John Doe protection will remain into place. So I think this is really on the part of Ms. Vaccaro an attempt to do an end run around the current orders, which remain in place, granting Mr. Doe the John Doe protection. We need to let the appellate process play out to see what the appellate court is going to do with this. If we are successful on our amended appeal, there's going to be a hearing in a closed courtroom. And at that time, the court can determine whether or not John Doe protection will remain in place for Mr. Doe. But in the meantime, if this motion, the current motion, is not granted, and the the plaintiff is allowed to file an amended complaint identifying Mr. Doe's relative, that essentially moots and negates and vacates the underlying protection that is still in place. So there's really no reason why this protection should not remain in place for Mr. John Doe at this time.
Okay, just so I understand then, Judge Denario entered a ex parte order permitting the case to go forward on a anonymous basis. Is that correct?
That's correct, Your Honor.
And there was appeal of that order, and that appeal has been dismissed for
sorry.
Final order.
Yeah,
lack of a final order.
He vacated it. He then vacated it, but stayed it pending the appeal, so that John Doe remains in place. The appellate court, sua sponte, not on motion of either party, issued an order asking the parties to brief whether or not the original appeal should be dismissed for lack of a final judgment. It just last week ruled that there was not a final judgment, so that the original appeal should be dismissed. The second part of the appeal, as to whether or not there should be a closed courtroom on the hearing on the underlying motion, was not dismissed. That's still pending. If we prevail on that, there will then be a hearing in a closed courtroom on the underlying motion. So as of now, John Doe protection remains in place. As of now, we're waiting, and we haven't had oral argument yet before the appellate court. I think that's probably going to happen next month. So we're still waiting for the appellate court.
But today is the underlying motion, is it not?
Well, no, today is the underlying motion on the motion before the court today is on whether or not, if plaintiff amends her complaint to add John Doe's relative as an additional defendant, whether that relative should also be afforded John Doe protection. Because if that relative is not afforded John Doe protection and is named under their actual name, that will identify John Doe and render the protections that are currently in place moot. So what we're asking for is, while the appellate court process plays out, and while any potential subsequent Superior Court hearings play out, that if the plaintiff is going to amend her complaint to name the relative as John Doe 2 or Jane Doe, that relative also has to be named as a John Doe or a Jane Doe. Because
have you never seen the internet? Do you know what internet sleuths do when they want to find someone? They find them. Every person that thinks that they have anonymity in this world, in this life, I mean, Karens are found out daily. You know, I mean, well, yeah, maybe who he's trying to hide from, I don't know, maybe, but his brother knew of the arrangement. So I don't know. We're gonna I don't know, let's see how this plays out. All I know is is Miss Vaccaro. She ain't keeping her mouth shut. And John Doe, he's gonna get found out eventually. Especially, when you hear more details.
Otherwise, it would render meaningless the current protections that are in place. So what's before the court today is our motion asking that if this relative is named as an additional party, they also be named as a Doe defendant.
All right, I understand your position.
Thank you.
Let me hear from the plaintiff.
Thanks, Your Honor. The parade of horribles that we just heard obviously is not spelled out in the motion that's before the court today. I will we made some arguments in our brief, and I know Your Honor will read those arguments. The brother-in-law that Mr. Nevis is so concerned about is already identified in the complaint that we filed almost a year ago, in fact, more than a year ago. By way of background, my client had a domestic partner relationship with the defendant in this case, and she worked for the defendant's brother-in-law. And shortly after she was assaulted in a domestic violence incident, she was fired by the brother-in-law. So we have an employment case against the brother-in-law and his business, and that is in arbitration. But we took the brother-in-law's name out of the complaint, but the complaint says that she worked for Doe's brother-in-law, names the business. It's already in the record. So this parade of horribles that counsel refers to, again, is completely speculative. He's seeking relief on behalf of a third party to keep that party's reputation sacrosanct. I will tell you, Your Honor is well versed with the public policy behind open courtrooms and the restrictions for the court in granting pseudonym status. Judge Gennario recognized that early on when he denied the pseudonym application. And there's just no good faith basis to grant this motion. And for counsel to say that this is just some kind of a vendetta really, I think, misses the mark. The defendant was arrested for assault and related crimes. And, we allege other wrongful conduct. So this is not some kind of, I got better things to do than file lawsuits over vendettas or bring in defendants to pursue a vendetta. I think our points are raised in our brief, and I would just ask Your Honor to review those. I don't think this motion is well taken.
Your Honor, may I respond?
All right, I'll take a look at the papers. Yes, you may.
Yeah, so, on the arrest, the charges are no longer pending. There was a diversionary program that was entered into. With respect to, we're not arguing on behalf of a third party. We're arguing on behalf of the defendant. I'm not.
No, I understand. Your argument is that the defendant's rights to anonymity, if any, would be compromised if his brother-in-law was identified on the record.
Exactly, Your Honor. Exactly.
Right. I understand your point.
It would, render meaningless the current orders that are in place.
If I could just respond briefly, Your Honor, I'm not sure how that would happen. I'm not sure how a public filing against another person somehow would defeat the anonymity that the defendant so strongly cleaves to in this matter. And again, Your Honor, Judge Gennario denied the pseudonym application because there was no reasonable basis for it. And that is still the case. There's no reasonable, this is not a case involving a minor sexual assault victim or something like that. This is somebody who just thinks he's above having his name in the public court filing.
I'll go back and I'll take a look at the record and take a look at your papers. and I'll give you a decision somewhat expeditiously, which means within 120 days, although I never get to that, hopefully. All right.
Thanks, Your Honor.
Your Honor,
I'm going to move on to the next matter.
Thank you, Your Honor.
And the next matter
Thanks,
I
Judge.
have. Let's see. Okay, the next matter I have is Carlin versus Wells Fargo.
Good morning, Your Honor.
Good morning, Your Honor.
Okay,
Good morning, yeah.
101 motion to dismiss. So would the parties please identify themselves for the record?
Good morning, Your Honor. My name is Sean Higgins. I represent the defendant, Wells Fargo Bank, the moving party today.
I am Gerard Carlin, petitioner in the matter.
All right, so let me hear from the defendant first, please.
Thank you, Your Honor. Just point of clarification, I think I see on my screen an anonymous, and I believe that might have been Mrs. Carlin attempting to respond to the roll call.
I don't see that on my screen. I think you may be misinterpreting the one that says SV.
No,
Unknown
Judge,
user. Okay.
Yeah, it shows up as anonymous on my screen, Judge.
Okay. Is there anyone else that wants to enter an appearance in this case? Is there anyone else we need to hear from in order for argument on this motion?
Your Honor, Carla Carlin is here on the line as well.
All right. So that's the my screen. It shows as unknown user. Okay, so we have Carla Carlin, Jared Carlin, and Mr. Higgins have all entered their appearances for today. Okay, let me hear from the movement.
Thank you, Your Honor. Again, Sean Higgins on behalf of Wells Fargo, the movement, the respondent in this particular case. As you indicated in your earlier hearing, Your Honor, I trust that you've read the papers and are familiar with the background history, so I won't belabor that. But my client, Wells Fargo, is nearly completed a foreclosure case in a separate pending matter that's been in litigation for over a decade. And the procedural history of that case, which is laid out in our motion to dismiss and supporting memorandum, is all available to the court on judicial notice. There is no dispute about the procedural history of that case and the many filings that have been made by the Carlins. Most recently on June 25th of this year, in that foreclosure case, the court entered an order sanctioning Mr. and Mrs. Carlin for their frivolous litigation conduct. And that sanction was a bar against them making any further filings in the foreclosure case to try to stop my client from enforcing its judgment. My client has a judgment that entitles it to sell the property at auction. This case, which was filed 2 days before the sanction order entered, is an open and obvious attempt to avoid the judgment that is entered against the Carlins. And it should be dismissed for lack of standing under the operative case law that we set forth in our brief. The court lacks jurisdiction to hear a collateral challenge. Mr. and Mrs. Carlin have, as we set forth in our brief, have an extensive history, litigation in multiple jurisdictions, multiple filings, but in almost every case, they repeat the same thing over and over and over again. And they challenge Wells Fargo's right to enforce the mortgage in the first instance, and that argument has been rejected by every single court that has reviewed it, including the Connecticut Appeals Court, Appellate Court, and the Supreme Court of Connecticut rejected a cert petition by Mr. Carlin. As we've laid out in our brief, Your Honor, Mr. and Mrs. Carlin are attempting to ask this court to impose its judgment in place of the multiple courts that have already decided that my client is allowed to foreclose. Mr. Carlin is the only party who has opposed the motion to dismiss. Mrs. Carlin is pro se. Mr. Carlin is a former attorney, and essentially he's been acting on his own pro se. And because Mr. and Mrs. Carlin's interests are somewhat aligned, he has been responding to all the briefs. But Mr. Carlin's opposition to our motion, in large part, quite unfortunately, accuses me and my client of fraud. And I won't spend more than a couple of seconds just to say, Your Honor, that issue, Mr. Carlin's argument, has been made before. It's been asserted for years that my client has misrepresented its testimony, that I have supported my client's misrepresented testimony in a variety of filings, that there's some obligation on my client's behalf and my behalf to withdraw this false testimony. It's all completely and totally contrived, Judge. There's no merit to it. But even if there were, the issue has been resolved against Mr. Carlin over and over and over again. My client most recently was scheduled to conduct the foreclosure auction on Saturday, August 2nd. Mr. Carlin filed a motion for an injunction in this case to stop the sale. The court did not rule on that motion. And so on July 31st, 2 days before the foreclosure auction, Mr. Carlin did what he's done twice before. He filed bankruptcy to stop the sale. The record is replete, Your Honor, with overt examples of Mr. Carlin's intentional bad faith, where he is doing nothing but trying to delay my client's rights to enforce its mortgage. And this case is just another example of that. Interestingly, Judge, in Mr. Carlin's most recent bankruptcy filing, which was made not in the District of Connecticut, as one might expect, but in the District of New York, the Southern District of New York, Mr. Carlin has apparently identified his address as being in New Rochelle, New York. The property at issue in this case is 10 Pheasant in Westport. Mr. Carlin deeded the property to his wife years ago, and now apparently doesn't even live there. So it begs the question in the first instance, what standing does Mr. Carlin even have to be filing a petition to set aside the foreclosure judgment of a property that he doesn't own and no longer resides in? It makes no sense. Much like so many of the things that have been filed in this case, they don't make any sense. My client has, the appellate court in this state has said my client has the right to enforce its mortgage through foreclosure. And Mr. Carlin and Mrs. Carlin cannot ask this court, as a collateral challenge to that final non-appealable judgment, to enter an order requiring a new trial based upon the arguments that Mr. Carlin has repeatedly made that have been rejected. So we would ask the court to deny Mr. Carlin any relief in this case, grant the motion to dismiss with prejudice as to both of the petitioners, and dismiss this case so that there cannot be a collateral challenge to the judgment. Thank you, Your Honor.
Okay, Mr. Carlin.
Thank you, Your Honor. Mr. Higgins ignores General Statute 52-270. Mr. Higgins ignores a number of cases decided by our Supreme Court. It has all been laid out in my memorandum of law in opposition to Mr. Higgins' motion. This is not a continuation of the foreclosure case. The instant matter is a petition to open the judgment based upon 4 different grounds. Number 1, failure to plead EMAP as required by the Supreme Court in the Key Bank case, Key Bank versus Yazar.
Has that ever been
statute-
decided? The issue decided? Has that issue ever been decided by any of the Connecticut appellate courts?
The Supreme Court
in this case.
Oh no, not for me. I'm sorry, Your Honor, not for me. But in Key Bank versus Yazar, at 347 Con at page 398, the Supreme Court says that EMAP, compliance with the EMAP statutes must be pled. There is no mention of this in the complaint in foreclosure matter or any other pleading in that matter. Number 2. Prior to the initial judgment in this matter, an EMAP affidavit was filed by Joseph Denage, who was an attorney for the predecessor firm to McCullough Raymer. That affidavit is 100% hearsay. It does not conform to any of the hearsay exceptions. And in fact, it has been a word for word, verbatim affidavit by the same Joseph Denage has been ruled as hearsay, unenforceable hearsay, in another matter in the Supreme Court. And I cite the case in my papers. Number 3, the judgment of foreclosure was obtained by misrepresentation and fraud. And let me explain. Under the case of Goshen Mortgage versus Andrew Ladakis, the general standard for a holder of a note to foreclose is that a holder of a note is presumed to be the owner of the note. It is up to the defendant to show who the true owner of the note is. If the defendant can prove the true ownership of the note, then the holder of the note, the presumption that the holder of the note is rebutted. Prior to, I'm sorry, there was a deposition of the respondents held in February of 2021. Prior to that deposition, a number of things had occurred. Number 1, Wells Fargo, which was acting as servicer for the trust, that owned the note, had issued a number of letters, and there had been an internal memorandum. Everything here is cited in my memorandum, stating that the ownership of the note was held by WFMBS 2007-2. The latest such statement was issued in July of 2015, almost a year after the case started. It was sent to an attorney named Peter Torres in New York on my behalf. Mr. Higgins, in 2021, January 7th of 2021, or January 8th, excuse me, issued a letter in response to a demand for document production prior to deposition, stating that he was not required to identify who the owner of the note was, and all information was contained on a URL, and he gave me the URL. The URL that he gave me was for a website maintained by the United States Securities and Exchange Commission, their EDGAR system. The EDGAR is, let me backtrack, the EDGAR is the public system that's maintained by the United States Securities and Exchange Commission for all securities that are filed with the SEC. So the URL was for Wells Fargo Mortgage-Backed Securities 2007-2 Trust. We then had a deposition in February where Jessica Reef Jones, who was employed by Wells as their, I believe the title was document specialist or a document production. Your Honor, I'm sorry, I forget the exact title, but she was employed to examine documents and give testimony at depositions, stated that the owner of the note was the original plaintiff here, HSBC, as trustee for Wells Fargo Asset Securities Corporation Mortgage Pass-Through Certificate Series 2007-2. which is the holder. So Reef Jones, on behalf of Wells and that entity, which I'll call Asset Trust, testifies that Asset Trust is the owner of the note and that it acquired ownership in February of 2007 from Wells Fargo. She also testifies that it was sold back to Wells Fargo by Asset Trust in 2019. This was false testimony, Your Honor.
So,
Maybe
Mr.
it
Carlin,
was a
just
mistake.
tell me, Mr. Carlin, have you previously made this argument to another court in another action?
Yes, I have, Your Honor. And the
And has it been, have you prevailed with respect to that
I have
argument?
not. Now, I have not. However,
Was that argument made in the foreclosure case?
yes, it was. Now, I have uncovered new
And
evidence.
Okay, before you get to your new evidence, and so
Wow.
judgment entered. In other words, the court did not accept the argument you just made to me.
The judge is so over this guy already. And did you hear his wife pop in? Wow. That was his wife on the phone. Yeah. The judge is just like, okay, I'm going to get to the meat and potatoes of this dinner because, yeah, this is too much salad.
So in the foreclosure case, that argument was made and not accepted. Now, you say there's new evidence that you have not presented in the foreclosure case?
That is correct. And I can't present it in the foreclosure case. And in fact, here's the problem. Excuse me, new evidence. I have Freedom of Information statements from the Securities and Exchange Commission that were issued in June of 2017. 2025. Those statements say they have never heard of Asset Trust. There are no documents. Let me backtrack. When you file a securitized trust or create a securitized trust, there are lots of filings that you have to do. You have to file registration statements. You have to file various documents. They have no record of those specific documents. Number two, I had obtained in 2024 statements from the SEC stating that they had no record of Asset Trust. I presented them to the court. On April 17 of 2024, Mr. Higgins came out with a memorandum in which he stated that, well, yes, the note was owned by Wells Fargo Mortgage-Backed Securities Trust, the trust, and not Asset Trust. Prior to that time, in a number of different filings with this court, Mr. Higgins said specifically that the note was owned by Asset Trust and not the True Trust. And I cite that in my memorandum.
Okay, so Mr. Carlin, you presented that to the foreclosing court and they did not accept
No, I didn't.
That evidence.
Hold on, Your Honor.
You're saying you did not present that evidence to the foreclosing court?
The prior statements of Mr. Higgins, no, it was only in April of 20. Okay, the judgment of foreclosure. Let me explain. The judgment of foreclosure was entered in January of 2023. I obtained the initial information from the SEC in January of 2024. I presented it to the court in April of 2024.
Yeah, this is the same kind of logic that squatters and sov sits try to use all the time.
Mr. Higgins then came out with his statement, which is cited in my memorandum, where he said, okay, the note is owned by the trust, the true trust, and not asset trust. By that time, Your Honor, the 4-month period to move to reconsider the judgment had expired. Now, Your Honor, I have to tell you something. I was not aware of the procedures to open up a judgment after the 4-month period, and I only found that out in approximately May of this year. So, I mean, I confess, I didn't understand the procedures. And so I kept arguing in the foreclosure court what I'm telling you today. What I didn't argue in the foreclosure court, because I didn't have the chance, was when Mr. Higgins made a statement acknowledging that the trust was the owner of the note. He had made prior statements specifically stating that the owner of the note was asset trust and not the true trust. And I'll tell you where they are.
What happened in the foreclosure, when you made this argument in the foreclosure trust? What happened? How did the court deal with it?
The court said, forget it.
Excuse me. The court said, forget it?
The court said, yeah, we don't buy it. Excuse me. The court said that they're the same thing, that asset trust and the true trust are the same thing. Well, they're not. They are not. And the only way that I can deal with this, Your Honor, number one, we have new evidence that shows they're not the same thing. You can't have a securitized trust and some entity that's not a securitized trust. They're not the same thing. Number two, there has been fraud, pure outright fraud. Number one, under practice book section 13-15, the party is responsible and must correct misstatements, misrepresentations made in discovery. Didn't do it.
Now, Mr. Carlin, have you made the claim of fraud in the foreclosing court?
No.
In other words, have you made this claim of that you were defrauded or the court was defrauded in the foreclosure action? Has that claim been made already? Argument been made?
No, I don't believe so, Your Honor.
You're saying you're making this argument in this case for the first time.
I believe so. I'd have to go back and look at the papers. I was working with an attorney in April of 2024. I don't believe he put that in the papers. I do not believe that, Your Honor, but I don't want to give you an incorrect statement, so I would need to go look at the papers and make sure
you don't
of
have
my
to do that. I'm gonna go back and take a look at the papers, just so it's very clear. I am going to take judicial notice of whatever is in the docket in the foreclosure action as part of the background in this matter. All right. Anything further you wish to tell me that's not in your papers? I mean, I'm going to read your papers.
Oh, no, I mean, it's all in my papers, Your Honor. It really is. But I do want to say this. I tried starting in 2021 after a memorandum of decision. In 2021 and again in 2022. On November 30, 2021, in docket number 247, page 2, Mr. Higgins said HBUS, which was what he referred to as asset trust, was the trustee of a securitized trust that owned defendant's mortgage. The securitized trust was Wells Fargo Asset Securities Corporation Mortgage Pass-Through Certificates, Series 2007-2 Trust, asset certificates. He says the same thing again on November 1st, 2022, in docket number 275.
And that's cited in your papers.
Okay, yes, it is. Now, Your Honor. Okay, yes, it is. Now,
all right, so I'm going to take a look at it.
Okay, fine. Now, also, let me say this. I'm sorry, if I may say one more thing. This is a petition to open up the judgment. I will be seeking an evidentiary hearing on these matters. I also seek discovery. Right now, discovery is stayed. Okay? But I need discovery. Discovery will prove ownership of the note, and once we prove in black and white, and I have requested I have requested the records in discovery, in document production. I have requested the records showing the ownership of the note from 2007 through, I think 2020 or something like that. That will prove who owns the note. And that will show whether or not there was fraud and misrepresentation and a failure to correct. And that failure to correct went on for 3 years, Your Honor. 3 years, from 2021 until 2024, when Mr. Higgins finally said, yes, admitted that, yes, the note is owned by the trust. He had an obligation to correct the misstatements of his clients, as well as to tell the truth about the ownership of the note, and he didn't. And that's how he got the judgment.
Okay,
Your Honor.
Mrs.
Your Honor.
Sorry, Mrs. Carlin, you've indicated you want to say something.
Yeah, I do, and mine is very brief. I was not a party with the petition. I didn't oppose it. I wasn't with it. I'm not a lawyer. I didn't know. This was my husband's action. And of course, I try to support what he's doing because he was a lawyer. I do, however, have to take a stance against Mr. Higgins repeatedly since the very beginning, trying to identify me as a non-person and an appendage to my husband, as opposed to being a separate individual, trying to loop me into things that I have not filed, accusing me of things I have not said or written. It has to stop. I'm an American citizen. I'm an independent individual. I'm an 8th generation Black American, and this has got to stop, Mr. Higgins. This has got to stop. You don't get to throw a loophole as
this is
identity.
this is not an appropriate. It's not an appropriate argument what you're making right now.
It's inappropriate to accuse me of things I have not done, Your Honor. Please.
All right. Now,
Your Honor,
I'm going to give Mr. Higgins an opportunity to respond.
Yes, Judge. Your Honor, if the court were to look in the foreclosure case at paper 278, that's a November 14th, 2022 motion for sanctions that Mr. Carlin filed. Mr. Carlin, and in some instances, Mrs. Carlin, in separate filings and in joint filings, have been accusing me, have been calling me a liar and accusing me of fraud for years. It's completely ridiculous. And I'm so sick of listening to it, Judge. But my point is, the questions you were asking Mr. Carlin, has he raised these issues? Have they been decided? Has he mentioned the evidence? Has he claimed the fraud? The answer to all those questions, Judge, is indisputably yes. Mr. Carlin's entire presentation today to you is a version of his prior defense of my client's foreclosure case in the trial court and in the appellate court. Mr. Carlin has accused my client of lying under oath. He's accused me of failing to correct things that needed to be corrected. He's accused me of not providing him with information. This January 8th, 2021 letter that I've sent him is probably cited in 40 filings that Mr. Carlin has made in this case. He's been arguing this nonsense for 4 years. 4 years. About some trust, asset trust. It's so confusing, I can barely understand it. Judge Lee has written on this. He wrote in the foreclosure case. He said, Mr. Carlin, you are wrong. You think that there are 2 trusts or separate entities. You are wrong. They are the same thing. Mr. Carlin has appealed. The appellate court has said no. He cannot continue in this court or any other to rehash and re-argue these things. They are in his papers over and over and over again. The fictitious entity theory, Judge, has been a theory of his for 4 years. It's been rejected over and over and over again. So when you look in the court's filings in the foreclosure case, Judge, you will see that the same things that he's arguing about today, about this new evidence, about the SEC filings, about the discovery, and I would note, Judge, so much of Mr. and Mrs. Carlin's arguments are focused to me, right? How many times did Mr. Carlin say Higgins, Higgins, Higgins? They have personalized my client's efforts to try to enforce a mortgage loan that hasn't been repaid in over a decade. All my client wants to do is conduct a foreclosure auction. And the final thing I would say, Your Honor, is that in terms of his actual memorandum in opposition to our motion to dismiss, where Mr. Carlin attempts to articulate the reasons why his argument shouldn't be rejected, he really does make two legal arguments. One is, I have this fictitious entity theory about asset trust or the true trust, and I'm going to tell you, Judge, once again, why that should win the day. You'll be the 9th judge that he will ask to review that decision. The papers deal with that. The EMAP issue, which Mr. Carlin raises, trying to cite the Yazar, is also been decided because Mr. Carlin hasn't ever raised EMAP in the 10 years that his pending foreclosure case was in litigation. So that issue has been long waived. We cited that case to the trial court. Then he went to the appellate court, and the Supreme Court denied cert citing Esikoff. The Esikoff case stands for the proposition you don't get a 3rd and 4th chance, and this is like the 5th chance. So
all right,
ultimately,
it seems like this case is going to turn on my review of the prior proceedings. So I will review it. I'll review the parties' briefs. I'll go back. As I said, I'll take judicial notice of prior proceedings.
So apparently every time it gets close to Wells Fargo winning, the defendant files bankruptcy to push it into another court or files some pleading or motion or something. He's been a nightmare client. Like, it's no longer your house, man. Sorry. And this sucks. Like, this, it's close to home because I'm going to be losing my parents' property very soon, actually. And I wouldn't pull this kind of BS. And I'm not an attorney that knows the laws. I just know it's wrong.
All right,
Thank you,
both
Judge.
in the trial court and the appellate court. All right. All right, so I'm going to reserve on that matter. The next matter I have on my calendar.
One other thing, Your Honor.
Yes, ma'am. I just finished on that, but do you have something new you want to add?
Oh, I just wanted to address that my husband does live here in Connecticut as well, and most of the
I'm
time.
not going to. That would raise an issue of fact. It seems to me that if it's pertinent, I'll deal with it.
I just thought you should know because Mr. Higgins raised it and he said something that wasn't true. That's all.
Okay.
Okay.
All right. All right. Okay. As I said, I'm going to reserve on that matter. I am not going to reach the issue of where Mr. Carlin lives. Okay. On to the next matter. It's El Quardihi versus Mason Street Import Cars. Motion to strike 105.
Yes, good morning, Your Honor.
Okay. Would parties identify themselves, starting with plaintiff?
Hello, good morning. My name is Chris Nicole Henderson, El Walderly.
Good morning, Your Honor. Michael Longo for the defendant, Mason Street Import Cars.
Okay, 105 motion to strike, 106 objection. I'd hear from the movement, please.
Thank you, Your Honor. I'll be very brief. It's our motion to strike. It's defendant's position that the plaintiff's complaint is legally insufficient Plaintiff filed her complaint, which alleges issues stemming from the purchase of a vehicle from the defendant. The complaint seemingly sounds in breach of contract, but there's no allegation of any actual breach of contract in the complaint, nor is there any allegation of how their agreement was actually breached. I do understand that plaintiff is pro se, and I understand that this is not something she may do every day. However, lacking that essential element of pleading any breach of the contract, her complaint cannot move forward and should be stricken.
How many counts are in the complaint?
I think there's one count, Your Honor, but it's not.
What do you understand that count to be?
I understand to be a breach of contract claim, Your Honor, but again, I'm not 100% sure of that.
So what you have in front of you is a pro se complaint, which, although not labeled a breach of contract complaint, appears to be a breach of contract complaint, not some sort of other complaint.
It seems to me breach of contract, Your Honor, but again, I am not 100% sure of that.
All right. Okay. I just want to make sure that there weren't other claims that were included in the count.
There's just one count, I would say, Your Honor, but again, it's not captioned, so it's just one count. And again, I believe it to be breach of contract, but again, not fully sure of that.
Okay. All right. Okay. So I've heard from the defendant, ma'am. What is your claim?
Well, I filed the complaint, and I did not, I gave a detailed explanation of what happened. The only thing that I did not put in there was breach of contract, but when I got advice, I went back to the court and I did an amended complaint. And in that amended complaint, I did add breach of contract in there. And then I restated what my reasons would be for, what my findings would be for the breach of contract and what happened with the sale of the car. And I just left it like that, and I just been checking back and forth with the courts to find out if anything new came up or if it was anything else I needed to do. I would have originally put the words breach of contract in an original complaint, but I don't know how it works because I'm not an attorney, so I've been getting help from outside to tell me what it was that I needed to do.
Okay. Well, what I'm going to do is I'm going to go back and I'm going to actually review your complaint. As counsel already mentioned, when we're dealing with a pro se party, we're liberal with our interpretations. So that I will go back under that standard and take a look at your complaint. I'll take a look at your original complaint now. With respect to your amended complaint, I'm going to guess that you didn't follow any particular procedure in terms of amending the complaint. You didn't ask for leave to amend, or it wasn't done within a brief period after you filed the original action?
No, I always kept checking, so I filed everything in the time matter that I needed to file it. And I did go back, and that's when I found out that I should put the breach of contract in here. So as soon as anything comes up on the court website, I automatically go and ask for someone to help me to figure it out, which they don't give you much help at the courts because they can't advise you. So I was just told that I needed to amend the complaint, and that's what I did. But everything was in a timely fashion. Yes.
Okay. So, counsel, I assume that your position is I should look at the complaint and not the amended complaint?
That's right, Your Honor. We did file an objection to the amended complaint in that plaintiff did not request leave to amend, and I believe it was more than 30 days after return date as well.
Okay. Is there an objection to my considering in this calendar the amendment and the objection as well, so I can decide them and look at them at the same time?
No, Your Honor.
All right. So here's what I'm going to do. I'm going to, ma'am, just so you understand, I'm going to look at your original complaint to see whether it would be reasonable to read that complaint as if it was a breach of contract. Then I'm going to take a look at your amended complaint and the objection to see whether I will permit the amendment under the circumstances. Now, if and I'm not prejudging this at all, if I rule that the original complaint should be stricken because it's not clearly state it was breached, if I make that ruling, and if I don't allow the amendment for various technical reasons, you still have 15 days after
Your Honor, we're
get
having
my
some
order
trouble hearing you again.
in order to call the substitute. All right, let me try again. Mr. Clerk, when did you start having trouble to hear me? When I was telling you about the 15 days?
I
Yes.
believe it
Yes,
was
actually,
within
right
15
around
days.
there.
Okay, so I'll repeat. If I do grant the motion to strike, and if I do not allow the amendment, then you would still have 15 days to file what's called a substitute complaint to deal with whatever deficiency I find in the original complaint. Okay, just so you're aware of that.
Yes.
All right, so what I'm going to do is I'm going to take this matter under advisement. I'm going to take both the original motion to strike and the objection, which was on the calendar, and by agreement of the parties, I'm going to take the amendment and the objection to the amendment. I'm going to decide that as well.
Okay.
Thank you,
All
Your
right?
Honor.
Yes.
Okay, Mr. Clerk, I believe that's the last.
Sorry, Your Honor. We are having a bit of trouble
Mr.
hearing
Clerk?
you again.
I'm sorry, this is my last matter.
Yes, Your Honor. This completes the docket for
Mr.
this
Clerk?
morning.
Okay, we are adjourned.
Okay. Thank you.
Court
Have
is
a
now
good day.
adjourned.
Thank you, Your Honor.
You too.
Oh, I bet the judge was never so happy to be done with the docket in all of his days. The clock of doom. I found out what they're saying when Sav sits do the yeah, that. It is I texted it to Eileen E. Carlin. Propria persona sui juris. Propria persona sui juris. So they just say that really fast. I'm sorry. Yeah, it really was terrible, but that's what made the beginnings part so funny. I was laughing so hard when I was watching it the first time around. Yeah, Connecticut, that's a wild one. That's a wild one. Well, it is actually a mashup of two separate Latin terms. I looked it up earlier. In propria persona sui juris means acting for oneself of one's own right and without legal disability. In propria persona or pro per describes a person representing themselves in court without a lawyer, while sui juris means having the legal capacity to manage one's affairs and possessing full legal rights. So they literally just took two separate Latin phrases and squished them together and said, this makes sense. Which, I mean, okay, yeah, it makes sense, but it's not a recognized court term, It's not something that the lawyers say, the judge he understands, you know, pro per, pro se. But what makes you think the judge speaks Latin? You know? Oh, thank you. There we go. Thank you so much. I know I said it about 3 different ways. Sui juris in prio persona. Yeah, exactly. And it means per se. But you know those soft sits, they really like their words. You'll have to report back if you live. No. Well, it really, it does, but it doesn't, you know? I mean, but they just assume that because they took 2 phrases and mashed them together, you know, everybody's going to know what they're talking about. They sound smart. Yeah. Oh, per se injectus, huh? Yeah. No, that's what you're hoping to get later, that you'll be denied. That ruling, that motion, that will be denied. Oh yeah, for sure, for sure. Well, what I love is when you have languages that are the same but different. If, for instance, okay, in Mexican Spanish versus Spain Spanish or Colombian Spanish, they're all different, but they're all Spanish, right? And there are actually words that you can say that mean exactly opposite from each other, depending on which region you're saying them in. And you can get yourself in a whole lot of trouble if you say the wrong one to the wrong person. I did not know medical terms were based on Greek. Thank you. I assumed they were based on Latin as well, but what do I know? Only what I look up and then remember for 5 minutes, and then it's gone again. No kidding, not with the wife. Not with the wife. Can I get a pro se? Is that what you meant, pro se? Yeah, I tried to learn Spanish. I know a little bit, just a little bit of it. Like I know enough that like, you know, like my neighbors are Mexican, and I know enough that I can communicate with them, but I mean, we've got the translator app for more in-depth conversation if I don't understand or if they don't understand me. But yeah. No kidding, right? And they love trifling with it. They do. They do. Ah! Chipito, mi pito, por favor. course I remember that one. Oh my gosh. See, I can understand it spoken better than I can read, but see what trips me up too is like names or places, things like that aren't like technical words, like nouns. They get me because I'm trying to figure out what word is closest to it in the English language to see if I can break the code, but then it's not actually a word, it's a name. Or, like I'll catch half of it, half of the name, and think that that's part of another word, and oh man. And if I put out 3 words, I expect 3 words back, and you can't do that. No, you put out 3 words and you could get like 8 back or 2. It's just, yeah, it's wild. You can speak the language of love. I can't. And French is one that just it gets me. I can't speak it. I have tried. Now, German, I was actually picking up better than I picked up Spanish or French. German was resonating with me. And I guess if I had more opportunity to learn it, that sounds wrong. It's the drive. Like I have other things I'd rather do. That's how it is. We're all given the same 24 hours in every day. It's just a matter of what we do with them. This is what I choose to do with my time. Learning another language. Okay, it'd be cool and all to say I can speak it, but I don't travel. Like ever. And don't plan on it. So there's not really a purpose to learn it for me. Like I know that's crappy of me, but I have to have a reason to do something. Why do I spend 15 hours a day searching through court dockets to find cases and edit them down? It's because you guys are my friends. That's my purpose. I'm going to stream it with my friends, hang out with people, laugh, have a good time. Learning a different language, like, what am I going to do with it? I always look at the what am I going to do with it thing. Fozzie in Texas, thank you so much. I love you. You guys make me smile. You are my reason. Oh, ouch. Rough one, Germany. One of my favorite comedians. Oh my goodness. You'll have to look up, and Eileen E. Carlin, you won't like it. I'm just yeah, I'm gonna tell you now. It's the train story in Russia. The comedian is so hilarious. I don't know if I streamed it on here, would that be fair use? Like reaction video? Can I do that? I think he would I think he would get to claim rights of the video. I think he would get to. But at any rate, I will find it really quickly because it's the best. It is the best. He's so funny. Russia train comedian. Okay. So his name is Bert Kreischer. I'm gonna pull it up here so y'all can see it. Whoa. Just because I clicked on it, YouTube, does not mean I wanted you to do that. Okay. Bert. Kreischcher. I am the machine. There it is. There it is. Okay. Share screen. All right, guys. This is what you're looking for right here. This face. This face. It would be... It is so worth your time. He is hilarious. I absolutely love him. Yeah. It's wonderful. It is wonderful. Definitely take the time. Watch the full story episode. He's so funny. Oh my gosh. Right there. Right there. Mortimer Duke's stamp of approval. Quindale. I've never heard of Quindale. I'll have to look that one up. I love comedy. For sure. If you can't tell, you know, it would... Stand up is great. And I love Kill Tony. Yeah. Kill Tony is another one that I really enjoy. One of my favorite comedians is he got his start on Kill Tony. Kill Tony calls him cerebral palsy. Or cerebral palsy. Kill Tony. Aaron Belial. I don't even have to look it up. Aaron Belial. Oh, he is so funny. The guy, he's mute. So, but he is hilarious. So he uses his phone. He comes on, he's got on his belt with some carabiners. He has a couple extra battery packs and charging stuff and whatnot for his phone and a speaker. And he sets it up and he uses his phone with some pre-programmed sayings, but then he'll type on the fly. And the suspense is part of what makes it funny. Like, you're waiting for his smackdown and you know it's coming. He is so hilarious. I love him to pieces. Yep, Aaron Belial. He got started on Kill Tony. Oh, yep, can't forget Fluffy. Fluffy's great. I love Gabriel Iglesias. I have never heard of Riff Tracks. I will add that to my list. I watch a lot of dry bar comedy. That Eileen E. Carlin you would like, dry bar comedy. There's no drinking allowed, so it's toned down significantly. But it's still funny. Oh, there's an old man. Oh, the best one-liners ever. Oh my goodness. Oh, he was hilarious. I know I sent it to C-Rex. Hold on a second, guys. I got this. I think I sent it to Mortimer too, but though I'd have to open up my Discord. Oh, I found it. Okay. Hold up. Oh! This video is no longer available due to a copyright claim by Don't Tell Comedy. See, that's what happens. That's why I won't do it. If I was to stream something that someone put a copyright claim against, it would demonetize the entire video, not just the one segment, of course. Demonetizes the entire thing. It removes it in a lot of cases, and all revenue goes to the person that made the copyright claim. So it could be like 15 seconds of clip that you use or whatever, and the hour or 2 hours that you spent doing other stuff still goes to whoever made the copyright strike. Yeah. Anyways, it was King of One-Liners. He's this old man, and he just says the funniest stuff. Words. Riff Tracks is these comedians who watch awful movies and say the stuff that we are all thinking, oh, I'm not really into that stuff. That I don't do that. Like I've seen people sitting on the couch watching videos and reacting to them and stuff in movies and whatnot, and I just can't. I can't get into that. And I know it's stupid because what am I doing? I'm reacting to courtroom videos and stuff. But dagnabbit. I mean, I edited them and picked them, and I'm streaming stuff that I find interesting, and I'm just hoping you all find it interesting too. So, I mean, there's that. Ava's going in her sleep. She's snorting. That was so funny. That caught me off guard. I don't want to wake her up. She said she's had a rough day being a princess. Spoiled rotten. No, it was Ava. I got Earl in from the porch, but Tiny Kitten is laying on a bag of clothes. So it might be days before she comes inside. No. She does. She loves laying in laundry. And now that I'm living alone, I put the laundry away right away, so she doesn't have a laundry pile to lay on. And out on the porch, there's bags of clothes that are meant to be yard saled or goodwilled or given away, whatever. And so she's laying in that now. So she's happy. She's a happy cat. All right, guys. I'm gonna go to sleep. I got a video ready to launch at 9 a.m. I've already got it scheduled. It is nobody behaves on Zoom court or something like that. It's the one from Judge Marlena Taylor. It's 3 hearings because they all went quick. So Fozzie's like, I'm not done with my shift yet. No, I'm not done with work. You can't go nowhere. What are you talking about? It's like 11:30 where you're at. I need my pain meds, and I can't take them if I'm streaming, because otherwise I fall asleep, and then I have to edit. Then I have to edit myself. Then I have to pick a still frame where I look alive, but I'm looking like I'm looking at the chat, and I have to paste that over the spots where I'm like, I don't do football. I don't ever do football. I don't like football. But I did hear that there's some green dildos being thrown onto the court. Like, that's hilarious. Like they did in the women's basketball games. I mean, I don't know anything about sports, but I'll tell you when a dildo hits the court. She's a great judge. She hasn't been live streaming for a while, but I've got it marked for whenever she does go live that I get notification. Hello, Jenny Green, sweetie. 7. You're 2 hours behind me. Well, you were there for it the first time around. Oh man, like I see the videos of the trending stuff, like the dildos getting thrown onto the court, or the Karens snatching baseballs and hats from little boys and girls. Yeah. That's the stuff that I see. I don't watch the games at all. I have no interest in them whatsoever. I am not a sports person. I'll play some bocce ball in the yard. But that's about it. That's about it. Oh, I know. And then those internet sleuths, they found the wrong lady at first and blamed someone for it. Didn't even look like her. That was the wild part. And then apparently they found the real one. But seriously, like every angle shows she did not have her hands on that ball. And she went up screaming that she did. But I like that the Marlins and was it Red Sox? Gave the kid swag. Was it the Cheryl Wagner that they were blaming? I know they so the what? Oh yeah, that's right. Phillies, Karen. Phillies. Yep. The kid got an RV? Huh. Wow. Can Karen come steal something from me? No. No way. That's wild. That's so cool. Well, and that was the Marlins that gave the goodie bag to the kid. The Phillies, he got a bat from Batter. I think I'm saying that right. I'm pronouncing it like Benny Johnson pronounced it. I would have said Bader, but Benny Johnson said Batter, so he looks more of a sports guy than me. Oh no. Wow. I know parking is a nightmare. You still watch Parking Wars. Yep, Polish CEO. I saw that one too. And he and his wife doubled down on it. And they both were saying, like, the child owes us a debt of gratitude because we taught the boy a life lesson. Really? Really? That's what you're going with for your shitty behavior? It's a life lesson for someone else? Oh, it's about time that they learn that there's terrible people in the world? You're an alpha male? Manuel, I would hurt you. Oh, somebody mailed me something. I don't know what this is yet. Treats? Are they treats? Is it treats? It just says to receiving department. Shipping department. Republic brand. Oh! Never mind, I know what that is. I know what that is. I had a product that that I bought that it had broken little pieces of plastic inside of it. And so I contacted the company and they replaced it for me. I'm like, what the heck is this? It's got tiny little chunks of plastic everywhere inside. And they said, yeah, that's not right. Oh, you didn't hear about the Polish CEO? Oh, yeah. Oh, he was a jerkbag. Oh, man. It is not. No. Never. It's tobacco. I'm sorry. I'll do it the right way. I'm surprised it didn't wake mine. Oh, it did wake mine up. That did. She didn't bother because of the box. She heard the. That woke her right up, hearing her bag crinkle. Oh, the CEO of Camping World gave the kid an RV and tickets to the World Series. That's amazing. The kid totally won. Karen can suck a ball. Yep. Everybody. I watched him say it. His wife says it too. Like, there's audio of it. Absolutely. Like, he hugged his boy like so hard, like, yay, I did something so good for my son. I'm so happy. And then, oh, Karen. I mean, you could just see it. Yeah, he was getting roasted. Like, people were saying that he should have fought the lady and blah, blah, blah. Oh, what kind of dad are you? He's a good dad. He didn't want the drama. He taught his son a good lesson right there. And look, they came out so much better than having a stinking ball or cap, or something little like that. They got the admiration of the entire country, for God's sakes. And they got an RV now apparently, and oh man, and he got the bat, and he got to meet the Phillies player batter, and yeah. I commend that father on how he acted in that situation, because too many people would have reacted to Karen, and we don't need that. We don't need that kind of drama. Let Karen have the stinking ball. It's just a ball, and better things come. Yeah, exactly. It's just a ball. Oh yeah, because darn well in a situation like that, if he would have aggressed her, he'd gone to jail. She would have screamed her lungs out for the police, and yeah, he'd have gone to jail. Who needs that? No, he's a good dad. He's a good human in general. Like, full stop. He's a good human. We need more people like him. And less like that Karen. Well, you give Cedar lots of extra pets from me. All right, guys. I really am signing off this time. My Wi-Fi signal is doing that teetery spot on between the 1 and the 2 bars. It keeps doing this little teetery thing. So I don't want it to pop off and not get to say goodnight to you all. So sorry, I didn't realize that messy cat food plate was right there. just hide it. Darn cats. I need to go wrangle a tiny kitten off the front porch, though. No poppy bark eaters. It's the thingamajig, the doodly doodly. I love you guys so much. You make me so happy. Be safe, be well, sleep sweet, and much love.